Court will now call 125-269, State of Kansas versus Jason W. Phipps.
Good morning, Your Honors, and may it please the court. Kai Mann of the Appellate Defender's Office on behalf of Jason Phipps. Is a criminal defendant entitled to a legal sentence or a sentence that may, at some point after considerable service, become legal? That's the fundamental question of this appeal. We assert that a defendant is entitled to a legal sentence at sentencing. Because Mr. Phipps was denied a legal sentence at sentencing, we respectfully request this court remand this case back for resentencing with a criminal history D and a sentence capped at 26 months via 2168-19. And the reason that this sentence is illegal and the primary way that the Court of Appeals went wrong is that counterman has nothing to do with this case. If we look to our precedent regarding sentencing and we go to Keel makes very clear that in a direct appeal, the penalty parameters for a crime are established at the time of commission. The penalty parameters, sorry, that's a tough one for me to say, under the KSGA have 2 points. You have the severity level of the crime and the criminal history score, which is a combination of the number and type of the prior convictions. But under 2168-10, as an effect, when Mr. Phipps committed the crime that he was being sentenced for, convictions that were declared by an appellate court to be unconstitutional could not be included in a criminal history score. Murdoch also doesn't change this because Murdoch states that the legality of a sentence per 2235-04 is set in effect when the sentence was pronounced. Again, counterman didn't come out until after a year, over a year, until Mr. Phipps had been sentenced. And so regardless of whether we apply Keel or Murdoch, Mr. Phipps has to be resentenced because counterman simply just was not a part of this litigation.
Counsel?
Yes.
I understand that whole line of argument. It makes clear sense to me. Would you agree that that all is premised on the notion or the fact that Betger found that the reckless form of criminal threat was unconstitutional?
It was, but that was also the only holding at the time Mr. Phipps was sentenced.
Well, that's what I want to go
Yes.
directly to,
Yes.
because I think the record is not nearly as clear as you just said that that was the only holding, because the district court judge, and when reviewing this, when reviewing the motions from your client objecting to the criminal history score, who's the same judge who did the sentencing at the plea, pretty clearly states on the record, I sentenced him, or I found him guilty of intentional criminal threat.
No, the district court said I found him guilty of both, which really means I found him guilty of neither. I found him guilty.
Well, okay, walk that
Yeah.
through with me.
Yes, okay. No, because so here's the thing. Let's imagine what happens if a state charges alternative counts correctly, because everyone agrees that criminal threat has alternative means based on the intentional or the reckless, right? There are 2 ways to do this. We could do it the sloppy way. We could just copy and paste the whole statute into a count and go from there. Or we could limit ourselves to 1 theory per count. And in that case, we have 1A, intentional criminal threat, 1B, reckless criminal threat. When a defendant pleads, one of those goes away because per Garza, you can only be convicted of 1 crime. So here, when we're saying I found him guilty of both.
But isn't that because of merger? I mean, you can do 2 different things, one being intentional and one being reckless, charged as alternative means in the same count. And the court can say, well, yeah, you did both.
But the problem is that you have to make those factual findings at the time you accept the plea. What the district court did here was went back and said, oh, but look, that's both. I've done all this. That is what Mathis, Apprendi, Decom, that is an imprecise and incorrect categorical retroactive fact finding that the Sixth Amendment forbids. So if we have to follow counterman on this stuff, then we also have to follow the other earlier Sixth Amendment decisions that forbid district courts from making these types of factual findings.
Why is it fact finding when this is a ruling from the same judge? I mean, that's one
Because-
of the unique factors of this case. You would
Right.
at least concede that.
Because when you do the modified categorical approach, you don't look to the facts to see what's committed. You look to see what the charge was and what the understanding was. And when you look at this, we can't make those determinations from the documents itself. We only have this judge several years later, who's also not very happy and not understanding Apprendi at all, who's making this ruling. But the fact of the matter is, when you do the modified categorical approach, the only thing we look at are the elements that the defendant was charged and sentenced to. And in this case, we can't do that because a sentence of both is a sentence of neither. Again, had this been charged correctly, had the state charged these things correctly, we would know if it was reckless or intentional because one of those would necessarily have to go. But because we don't know, the state is in a position here trying, in their petition for review in their supplemental brief, they're trying to claim that I'm trying to relitigate this prior conviction. I'm not. All I'm saying is we don't know what the elements they were. The state is in the position here trying to relitigate this past one into intentional when we just don't have any evidence for
The
that.
count sets forth the elements, does it not?
It sets both.
Correct. And the district court found him guilty of both.
But you can only be sentenced to one. So every single thing that supports this being intentional equally supports this as being reckless. But this determination wasn't made until several years later at this current sentencing, which is forbidden by the Sixth Amendment. Long Apprendi, Mathis, DeCom, Dickey. I mean, I'm a veteran of the comparability wars. I know how these things work. And this is post hoc fact finding. And so at the end of the day, we have a district court who was told how to do this right and got it wrong. I filed a summary, so Mr. Phipps appealed. I filed a summary disposition motion on this 2 months before counterman comes down. When the state's briefing comes, counterman hasn't even been released yet. And then I lose on counterman when Mr. Phipps has already served the entirety of his felony sentence, which this is also a case between the difference between probation and prison. So this is why it's so crucial that we apply the law in effect at the time, because Mr. Phipps had no other choice. So it is our position that counterman is completely irrelevant to this case under Kansas law and should not be followed, regardless of whether you follow Murdoch or Keel. Mr. Phipps' sentence is illegal. And I'm actually sitting here trying to decide if I want to talk about counterman or not, because I don't think it applies at all. But I also think that counterman is incredibly distinguishable and frankly, a terrible case. We're reading Bacher, we read the discussion about Black and how a reckless mental state just doesn't jive with Black and it just doesn't fit. When you read counterman, it's like you're reading two different friends. You read section A, and you got the whole history of the First Amendment. It all sounds pretty good. But then it's like you have section B that just doesn't fit. It just doesn't fit. And Sotomayor's concurrence, Justice Sotomayor, lays this out. And Justice Sotomayor's is really aimed at statutes like ours, because we got to think about the differences between Colorado statute here. And the Colorado stalking statute required repeated communications. It required those communications be made to specified persons, and it required that the specified person or the target actually suffer harm. Reckless criminal threat in Kansas criminalizes making statements that recklessly disregard the possibility of causing fear. Possibility of causing fear. No actual harm, no specific topic. I could be muttering to myself about how angry I am about this court, and someone could overhear me, and I've committed a criminal threat. The Kansas criminal threat scheme, and I think if we sent this one up to the United States Supreme Court, they would have to recognize this, because this scheme under recklessness inherently is going to fall into criminalizing political speech. And we also got to think about Section 11 of the Kansas Constitution. Now, under Section 11, we got to remember the context in which Section 11 was made, right? It was bleeding Kansas. In fact, right before the Wyandotte Constitutional Convention, they passed what was called the Peace Act, the Kansas Territorial Legislature did. Something I've never seen before. It immunized prosecutions for all crimes in certain counties arising from political differences. Now, we take that context, the political heated situation, and we have Section 11 of our Constitution, Bill of Rights, which is far broader than the First Amendment. Now, I've actually, preparing for this, read the Wyandotte Convention, and that was a slog. But I did find out something interesting. One, banking was really weird back then. That's just kind of interesting. But what's really important for this argument is that when there was a debate to add an ex post facto clause or a bill of attainder to the Kansas Constitution Bill of Rights, those motions were tabled because the United States Constitution provides those protections, right? So from here, we should see that our Kansas Constitution shouldn't just be providing merely duplicative protection of the United States Constitution, or else that wouldn't be in there. And furthermore, when we look at the times, If we want to do originalism, we have to take into effect the times. The Fugitive Slave Act, the Buchanan administration breathing down Kansas' neck and causing violence. I think the framers of the Kansas Constitution, if for anything, wanted the Kansas Constitution to provide more rights than the federal Constitution, which we frankly went over to war shortly after the Kansas Constitution was passed because it didn't have enough rights. So when we look at all this together, the differences in our scheme, the way that Kansas sentencing law works, the differences in Colorado and our scheme, there is no legal, just, or good reason why this criminal threat conviction should be scored. And with that, I don't have any further remarks. I'm more than happy to take any questions. But with that, I would sit down and see if I get back up on rebuttal. Thank you.
This court has two pathways to affirm the district court. The defendant can defeat both of them, so the conviction and his scoring should be affirmed. First of all, basically everything he said after he disagrees with Counterman is irrelevant. This is not a collateral attack on a conviction. He doesn't have the ability to make any kind of constitutional challenge to that conviction in a motion to correct a legal sentence, which I guess he's raising for the first time on appeal. The only reason he gets to try and say that this conviction isn't valid is because the state statute allows it. There's no Apprendi issue. There is nothing here that can be a constitutional challenge to that prior conviction. The statute allows it if the prior was unconstitutional. Here, we now know, based on Counterman, that prior was never unconstitutional. We also, based on what the district court itself found, know that the district court found him guilty of both intentional and reckless. At that point, I'm just not sure why there's any problem. He was found guilty of the intentional version of criminal threat.
Let me ask you a question. Your underlying premise is that Counterman applies to our statute.
Yes.
What support do you have for that?
Counterman could not be more clear that recklessness is a sufficient mens rea. This court decided Boddiger on, is that how you say it? On First Amendment grounds and saying recklessness wasn't sufficient. The majority in Counterman cannot be read as anything other than directly contradicting Boddiger.
Okay, so you're saying that's binding precedent on us and
Yes, this court is bound by the United States Supreme Court's interpretation of the First Amendment.
So, were you done, Justice?
Yes, I am. Thank
I'm
you.
sorry. Let's say we grant your argument.
Okay.
Counterman overrules, I say Betker, I don't know.
I don't know how to say that.
Counterman overrules that. But we do also know from our illegal sentence case law that a sentence's legality is determined at the time of sentencing.
Yes, except
And
for
so, at the time this sentence was pronounced, a proper criminal history score, Counterman hadn't happened yet, was controlled by Betker. So why isn't the state just stuck with that?
because this is his direct appeal, and in a direct appeal, changes in law apply. That's been very clear. It's been clear in Murdoch. It's been clear in any case that we ever have a change in law on. So he took a direct appeal because he didn't like the district court's decision, and that had just had misfortune that Counterman happened. That means under the law that his conviction is now constitutional because that change of law applies.
But the statute, okay, so let me ask my question maybe in a better way. The statute on which Phipps relies says, it sets forth a factual scenario. If an appellate court subsequently finds, and I'm not quoting obviously, but if an appellate court subsequently finds that the conviction was unconstitutional. And isn't that factually true here, regardless of what even if Counterman totally overrules the appellate decision that found the conviction unconstitutional?
Yes, but I do think it would be absurd to say that just because this court made an erroneous decision in Betker, I'll try and say it the way you do, that no criminal threats that are reckless can ever be scored again. Like that just seems.
But isn't that what the statute says? I mean,
This,
that's, as I read the statute, that's exactly what it says.
the statute says has since been determined unconstitutional by an appellate court. I mean, that reading then means that if the Court of Appeals says that it's wrong, but the Kansas Supreme Court
Right.
flips it.
That's
I-
exactly what it says. And doesn't the legislature, don't we typically, and oftentimes the state asks us to just
Sure.
simply enforce the plain language of the statute?
I think that in the context of criminal history, we not only look at the plain language of the statute, we do look at the statutory scheme and its purpose, which shouldn't be to negate constitutional convictions for criminal history scoring. That just seems incredibly counterintuitive. So I don't see this is much different than what this court did in, or my interpretation anyway, is much different than what this court did in Keel and Terrell and all the other cases where we look at the actual entire sentencing scheme, not just this one sentence in isolation, and say it doesn't count if it's unconstitutional. Well, a court has to hold its an appellate court has to hold its unconstitutional.
How should we interpret that language? Like, do you have substitute language that we would write in our opinion? It doesn't really mean this, it means this.
Has been determined by an appellate court, has correctly been determined constitutional by an appellate court.
So
Is-
what I think what you're saying is we look to the most recent pronouncement of the
Right.
highest court.
Yes, because other than that,
that.
we now have to go in and I guess fix the statute.
Yeah, it just seems like you're asking for a pretty dramatic change in the language.
I will say that that also seems to be an argument that the defendant himself has never actually made. He's not said that this language is the reason we can't do it. He's just trying to argue Counterman
Okay.
was wrong.
But that literal interpretation is at least consistent with our rule that you determine legality at the time of sentencing.
Yes.
Okay. So I guess that maybe if one were to argue that cuts against the absurdity, how would you respond to that?
I do think that if this court wanted to just limit it to at the time of sentencing, Counterman wasn't there, Bakker was the law, and so the recklessness can't be scored, that I would agree is less absurd. I do think, though, the problem for Phipps here is that we still have this alternate path. He was convicted of intentional criminal threat. It's also kind of a reason you can avoid all of this together if you felt like it. But he wasn't convicted of intentional threat. There is no unconstitutional conviction at issue. It was scored properly. So under either avenue, either what the Court of Appeals did in this case or what the district court did in this case, his criminal history score is correct.
Am I correct that we don't have the underlying documents from was it a 2010 conviction? Or maybe a 09
Recod, but
conviction?
I don't remember the
Yeah.
exact
So
date.
the criminal threat conviction that we're talking about,
Hmm?
am I correct that we don't have
I did not
like the
relook,
complaint and so on in the record here?
look at the record for that recently. I apologize. So I'm not sure. I assume your reading of the record is
and-
correct.
Well,
I know I had the underlying facts, which makes me think at least there was a plea hearing that's in there.
so that was a background to my question of what do you think we should do with the district court's declaration about what happened at the original sentencing,
Well,
or excuse me, at the original plea
it
hearing?
is my opinion that every time a defendant pleads to both the reckless and intentional version, that is constitution, or not, that is fine, because the only reason the defendant gets to challenge it is under our statute. Under that statute, the state just bears a preponderance of the burden to prove that this was intentional conduct. This is not Bakker and Johnson. There's no jury unanimity. If we can, by a preponderance of evidence, say we charged intentional, that's in the complaint, and the facts support that by a preponderance of the evidence, we're done. And we did that here. The judge said, listen, when you have a charge, I am required as a factual basis by statute and by this court's case law in Edgar and another case, I remember Edgar, to find that what was charged was proven beyond a reasonable doubt, that the facts supported that here. And the facts supported an intentional criminal threat. I think that's true every single plea in every single case. So it's my position that when a defendant pleads to both intentional and reckless criminal threat, that the conviction still gets scored. I think here, though, we have even stronger facts because the district court said, when I did that, I found intentional. So that even more strongly proves that by a preponderance of evidence, that there was in fact intentional conduct. There are no further questions. I would just ask this.
Fine.
Yep.
I heard your opposing counsel say the felony sentence had been served.
Yes.
And it seemed by math that that was likely when I was reading the material, but I don't see that you have filed any arguments of mootness or change of custody or anything to bring that.
I
Is
have
that correct?
definitely filed change of custody to the Court of Appeals. And he put, at least I'm pretty sure, since the docket's down, I can't.
Yeah,
I'm
that's the same problem. I
very,
see that either.
yeah, very sure that before the Court of Appeals, I filed that because then in my brief, my first brief, I argued mootness. And then when counterman happened in the supplemental brief, I recanted my mootness argument and said the state is not arguing mootness. And then the Court of Appeals relied on the fact that he is still serving his misdemeanor sentence. And I checked as of yesterday, he is still serving his misdemeanor sentence.
That matters since we have a,
I don't,
does, these issues don't affect the misdemeanor? I mean, if you haven't
Right.
made the argument, that may.
yes, I have certainly not made the argument, but I don't believe that the criminal history score affects the misdemeanor sentence at all. Thank you. We would respectfully request that you affirm the district court.
And may it please the court, I just got a couple of quick things I want to hear. I heard counsel say there that there's no Apprendi problem here. There's clearly an Apprendi problem here. Inclusion of this criminal threat takes them from a D to a B, adds 1 month incarceration, and frankly puts them in incarceration in the first place at all, because this is a probation prison case. Secondly, Keel. When we're talking about the 6810, this is literally Keel. This 68 D910 is just a different subsection of the same statute at issue in Keel. To do anything else differently than Keel would just be a radical departure for the purposes of saving these criminal threats. Secondly, Justice Stiegel asked about the documents. I did file a summary disposition motion in the Court of Appeals that had the complaint, that had the journal entry. We can't tell from these things, and those are the things I'll attach. The third thing I want to point out is that 68.
Do those things include the actual transcript of the plea hearing and the plea document itself?
No, my thing only includes the PSI, the complaint, and the journal entry. But we got to be a little bit careful here about looking at the plea colloquy because we can't find facts. We can't find facts. We can't say, oh, this person, clearly meant to threaten somebody. All we can do is find the set of elements the judge accepted. And so when counsel was up here saying, yes, the judge found him guilty of intentional, I don't know why we're doing this, everything she said is true of reckless. A judge also found him true of reckless, found him of both, found it does both. So really when we come back at this sentencing, we're just backwards picking and choosing, which is what Mathis, DeCom, and the entire Sixth Amendment and Apprendi forbids. The time for the state to litigate the intentionality of this threat was back in 2002. But they didn't. And so now they're stuck with this ambiguous. Again, I'm not trying to say it's one or the other. I'm simply pointing out that we can't tell, and the judge making a backdated decision doesn't save that. And finally, I just got a question about mootness from Your Honor. I don't remember getting a custodial status because he's in jail. I do remember the prison one, but he was still in jail. One, I don't think this should be moot because if he's overserved on his felony, he gets time off in his misdemeanor that he's still serving. Two, this is
I was going to ask you, is that correct?
That is correct. Especially if there was any question of that not being correct, I think as soon as Hopkins came down, you have to get that because you're entitled to every day you've served on something. So if you've overserved, it's got to go somewhere. And then thirdly, I've still got a second issue in this brief. I did not touch on it. A plain, and I think it plays well with Hopkins because a plain reading of 6819 and 6606 show that this artificial conflation between misdemeanors and the grid and they don't play together isn't just true, especially when 6019A incorporates 6606 in. And finally, if this court is going to do anything on mootness, I would really appreciate a chance to brief it because obviously I didn't have any notice about that until now. So with that, I see I'm out of time and just, I would really urge this court to follow Kansas law, enforce its prior sentencing decisions, don't make sentencing any more complicated than it needs to be, and remand this case for Mr. Phipps to be sentenced with a criminal history D and a 26-month cap sentence. Thank you.
Yes, actually just.
Oh, yeah, that's the prison one, right?
Yeah.
Yeah, no, yeah, I knew that. Yeah.
Nothing's.
Yeah, but he's still in jail, so.
Yeah, and I think that's what your counsel said. We can pull this, I just didn't have it, so. I appreciate that. With that, the court will take this matter under advisement.